Hello everybody, Dave Weigel, parental alienation activist and warrior. This video is for the legal beagles and the at-home investigators that have an interest in wanting to see the actual nitty-gritty details of where exactly the fraud lies specifically. We'll be going into court in 1 week's time to validate the most fraudulent document I've ever seen, let alone purported to be a government document of accuracy. It's just absolutely absurd. Before we get into this, why me? Why am I putting testimony out in the court of public opinion this way? One very simple reason. Because for 6 years, I've been denied the ability of due process, of being heard. For 6 years, in January, I loaded 1,600 files. I stayed up 2 days in a row, no sleep, to get all 1,600 files over the last 5 years, outlining and proving the 30, 40, 50 acts of fraud a child could follow. That has just blown my mind. And as I talk to many, many people in my parental alienation support groups, which surprising to me is mostly women, it got me to understand something much deeper, that this is not, a father's rights thing. It's, this is a human rights thing. In this system, whoever's got the money and the will to buy the dirty deeds gets the power and gets the ability to abuse and pull off this parental alienation and child abuse. And it's scientifically, the science is in, it is child abuse. The fact that the legal system can pretend that the science is not in is one of the many, many absurdities. But why me? Why not a lawyer be doing this? Well, it only took me 7 lawyers to fire to realize that in this particular system, your lawyer does not work for you. It's called a friendly attorney. Friendly attorney works for the system. They work for exactly what pays them the most. And guess what? Wrapping up a case early does not pay them the most. And it's just that simple. All right? So before I get into this, I just wanted to take a second, to just speak about me. You're going to see, as much as I try to keep my emotions at bay on this, it's very, very difficult. I mean, it's the epitome of personal. Robbing one's children and trying to destroy one's livelihood, is, murder is taking everything from a family. You take a man's child, you take a man's children, take their livelihood, take their freedom. How's that different? This family court is organized crime. They've just moved outside the system to inside the system. And anybody who has been through this system agrees and knows. And I hope to just be part of a movement that really stands up against this absurdity. Because if we are a society that wants to consider ourselves a developed society, well, we need to do something about the fact that we have okayed a system of government that produces on a regular basis mass child abuse. So I'm going to go through this exact quick document here, okay, that's going to be validated in 7 days. Mark my words, it is going to be validated as true, accurate, and a legal judgment based on facts and evidence as per the rights and laws of this country. You decide. But first I just want to say, I'm not a doctor. I'm a patient. I've been working with the same brain coaches for 8 years, and thank God for them. They've kept me together, which, by the way, all of them have written countless letters to the courts with no consideration whatsoever from my actual doctors, who's been actually seeing me for this entire period. I'm not a parental alienation therapist, but I have been helped by some great ones. Jill Weiss has been brilliant. I mean, she's the one who told me, Dave, the only time I have ever seen anything good happen has been when people have taken over pro se and become their own attorney themselves. What? That's the most absurd thing. Is what's the old rule? Only a fool represents himself. Well, you got to meet absurdity with absurdity, insanity with insanity. And I know that maybe not everybody can do everything that I've been doing here, but with hopefully a lot more people joining in to educate people about this system, that more and more people can stand up for themselves. I'm not a lawyer, all right? I'm on the other side of the coin. I'm a certified financial planner. I am in the most regulated profession on the planet for two things: honesty and fair dealing. The complete opposite spectrum of a lawyer is supposed to be regulated by the Bar Association. Oh, God. I'm not a legal expert. I'm just somebody that has spent 12 years with such immense focus on trying to save my life, save my children's lives, and get myself out of this mess. I'm no PhD either, but I cannot imagine a single PhD on the planet that has spent more time, more hours, more passion and focus on trying to understand all the ins and outs of this system. So I'm going to quickly do my best here and make permanent public record of this absurdity. So the first thing to notice about this document that was also cited and printed in Richard Luthman's article just recently, that is posted on the internet for anybody to see themselves, is exact document that was posted. But this one says, received by NYSIF, that's the court official system, on 1/10 of 24. 1/10 of 24. I wonder why that is. Oh, well, I had to make a couple of corrections in here. Let's see, but let's go through the actual chronology of actually the facts about key dates involved. So, as previously reported and shown in the articles written and in the work that I've done, that I drafted up this family divorce agreement, which calls an end to the whole divorce for the benefit of our children, which I've spoken about before. That was on October 23rd. On October 29th, it was signed by Georgina Dimison Weigel and sent back to me. And I had been fighting for 6 months to get access to the official system of NYSIF since March with Dr. Vince Carbonell, a very, very good friend, who could not believe the level of obstruction that he witnessed by the courts providing the wrong forms for me, answering questions with questions. All of this is listed in the 1,600 pages that has been submitted on NYSIF that has gotten zero attention. Judge just pretends doesn't exist. Doesn't exist. Well, it does exist. It's on the system and it's not coming off, and it's only going to be explained and only going to be analyzed by AI. In this case, it's only going to be proven by AI. But I'm going to go through this article, this fraud document, line item by line item, to speak specifics, actual specifics. So on 12/13, December 13th, I emailed the family divorce agreement to the courts, notifying them that I still don't have access to the NYSIF system. But since this was signed long ago, it was important that the court had record and that Google keeps record of exactly when everybody was notified and when it was sent to them, which is there forever. And amazingly, this referee report shows up on 12/15. And on 12/16, I get an email from the court's assistant, again, Miss Babette Gambino, saying, sorry, we can't accept documents that are sent by email. Wrong form, wrong process, wrong technicality. This is how the fraud works. This is how they get to play hear no evil, see no evil, speak no evil. On 12/13, I email the courts. On 12/15, this referee report shows up, but, the original signature is December 4th. So, the referee had it this whole time. It was done well before the court even noticed that there was a family divorce agreement. But, it wasn't submitted on the system until the 15th. And on the 15th, they got a chance to explain that, the email that I sent with the referee, with the family divorce agreement could not be accepted. They could not know anything about it. They just don't know. Because it was sent in the wrong way, they have no idea what the family's global agreement has been, what their joint global settlement is. They just have absolutely no idea. Okay? So let's get into this here. All right? So in the Supreme Court, okay, from Judge Tundra Dawson, okay, it says, by the order of Honorable Tundra Dawson, dated January 6, 2022, the financial issues of equitable distribution, right? That means fair distribution, right? Equitable, that's what that means. Spousal maintenance. Spousal maintenance? Why would spousal maintenance be involved when you're dealing with two individuals in the top 1% of all income on the planet? Isn't that supposed to be for somebody like my mother? 4 kids, who stays home, takes care of the kids, is the CEO of the house. Isn't that who spousal maintenance is for? I thought that there were basically all these movements for equality in this country. Child support, which obviously should be. Add-ons. That seems vague enough to throw anything in there. Counsel fees are always thrown in at the end. That's a tactic, no? And other fees. Jesus, what can't fall into other fees? And it says that, if any, that this was all referred to the special referee to hear and report. This was referred to the special referee, Sue Ann Honig, for her to hear and report. But we've never met her. We don't know what she looks like. We've never submitted any documents to her. There's never been any back and forth conversation. How can she hear and report if none of us know what she looks like? This matter was assigned to the undersigned special referee for hearing on May 21st. This is important. These 2 dates are very important. So it was assigned to her on March 21 of 2023. And the parties were contacted via email that the trial date was on Monday, March 27th at 2 p.m. and that no further adjournments would be granted. What does he mean by further adjournments? Of the 4 years of court cases that had gone on, this is the first time. This was the preliminary meeting and appearance to discuss the financial arm of the divorce at all. So in a divorce, you've got 2 sides. You've got the custody side, and then you've got the financial side. The financial side is supposed to be cut and dry because numbers are numbers, unless there's some reason you don't have the numbers, and therefore you got to just pull them out of the sky, right? So this was decided to be referred to her on the 21st, and then it had to be commenced in 6 days. So 4 years for the custody. We started on February 28th of 2019. This is now March 27th. We're starting the financial end of the trial. And even though this is the first appearance, no adjournments can be ordered. Why would that be? if this is a trial, if this is an actual legal process, what valid reason could there possibly be that we need to prepare in 6 days and it can't be postponed? Further complicating things, on March 21st, I was told by my attorney, Taylor Koss, that he's out. He's quitting. He's making up this excuse, and it says here in the bottom that he's never been the attorney for the financial side. Now, is that how you hire attorneys? Is that standard? Is there an attorney for the custody side and then an attorney for the financial side? Didn't happen on the defendant. It's the same attorney that was handling both sides. Why would that be valid? And Mr. Koss was paid. I paid him, according to the 1,600 files that were submitted to NYSEF, in there is the retainer agreement and the last payment that showed that he was paid through March 31st. So if he's paid through March 31st, isn't March 27th before that? Why would he be so adamant that he does not represent me anymore and he's not showing up? And on top of it, all of the emails I received that day that are loaded on NYSEF in the 1,600 files say how vital it is that I show up alone, unrepresented. He's not going to be there. But instead of postponing it, no, I have to show up, and I have to show up by myself. What possible legitimate rationale could that be? Could it be that I was set up to be arrested that day and Mr. Koss just didn't want to have his hands anywhere near it? Again, doesn't take a very skilled investigator to kind of put these things together. Nor is it legal for an attorney to just decide he's out, which I believe Richard Luthman flushed out in the article in December. So he was my attorney. He wasn't officially released and just decided he was not showing up because he knew the fix was in. But, so this is the first and only hearing on the financial side, and Mr. Koss knows that they're going to be police waiting for me, and I'm going to be arrested. So doesn't that mean that I was going to be defaulted that day anyway? Now, that's obviously not what happened, okay? Said that no further adjournments would be granted. Both sides acknowledged that they would appear. Yes, on the Friday before, I said, okay, I'm forced to be there. I'll be there. I don't understand how or why. I'm being forced and advised by my attorney to show up unrepresented. And he said, oh, it's only preliminary. It's only preliminary. Not going to go over too much. Not going to go over too much. Well, turns out that was the entire appearance for the entire financial side of this case. This is part of the absurdity. So I acknowledged I would be there. I'd be there on that Friday. Unfortunately, on that Sunday morning, I got a text from my friend Todd, who said, did you hear about Adam? And I said, I have no idea what you're talking about. And he gave me the news that one of my best friends started with in the business, got in a horrible motorcycle accident. I don't want to get too much into it because it's already been discussed out there. And I heard, and I jumped on a plane as soon as I heard, within 2 hours. And while I was in the air on March 26th, as soon as I landed, I turned my phone back on. I got a text from his wife, and he had passed. He was in the ICU since the Tuesday or Wednesday, holding on, and unfortunately couldn't hold on any longer. By the time I landed, 11 o'clock on March 26th, Sunday, the night before our trial, I found out that he had passed. And it said, after the parties confirmed on March 27th hearing, plaintiff David Weigel contacted the special referee that he could not attend because his dear friend was in the hospital. No, when I reported to the special referee that I could not attend, it was because my friend had passed away. He could not be in the hospital if he was no longer with us. But the fact that it said it was in the hospital is reason for that. The plaintiff was directed to submit proof of medical emergency. Prove he was a friend of yours. This is suspicious. We've got you set up for Monday. You know, this throws a monkey wrench in our plan. You got to prove that this guy is your friend. So as offended as I was, I collected all the text messages of him texting me a week before, you know, discussing things about his kid. Pictures of us on vacation together 10 years earlier. Took me a couple of hours to put all together because I was told that it needed to be submitted, okay? And if no documents were submitted before the hearing, he would be deemed in default. I was told, better get all this before court at 2 o'clock. Now it says, it is noted that the hearing was scheduled at 2 p.m., but court breaks at 1 o'clock for lunch. Yes, this speaks to Richard Luthman's article about what did she have for lunch. So I was not only instructed to get it there before court, I was instructed to get it there and know that court takes lunch at 1. But it gets better. So it's noted that the hearing was scheduled at 2 p.m. The court breaks at 1. Prior to the commencement of the hearing, no documents were received from the plaintiff. That is a 100% falsity. I submitted the proof, and it's been online and written about in the article. It was received at 1:27. Every bit of proof verifying everything that they asked for at 1:27. This document, this legal document, says something specifically false that is specifically provable. The email exists forever at 1:27, shows delivered to the special referee at 1:27. But this legal document says no documents were received from the plaintiff. Therefore, the special referee deemed the plaintiff in default. So once again, because I was told to stay in Florida, I didn't show up for court and I lost custody of my kids. Because this document says no documents were received by the plaintiff, I was in default, and therefore that means they don't have to look at any documentation whatsoever. Now they can just pull all these numbers right from the air, which is exactly what they've done. So after giving the plaintiff, it gets worse, 15 minutes as a courtesy from 2 to 2:15, okay, another provable lie. So you could say she was on lunch from 1 to 2, but now when it's sitting in her inbox at 1:27, provable that it's in her inbox at 1:27, she said, oh, I gave you till 2:15. Why didn't she see the email? There's from 2 to 2:15, she's able to see an email that was received at 1:27. So even if some of these things are a 1% probability of being true and can't really be proven, two things right there are absolute 100% false facts, 100% provable false. So the hearing commenced forthwith. The defendant's counsel argued that the plaintiff's non-appearance should result in the plaintiff being deemed in default. Okay, the lawyer is taking advantage of it. That his medical excuse was not founded, but get this is just Class A Daniel notes. It's not founded because his friend's accident was on March 22nd, but then the funeral was not till March 29th. But wait a second, you said that he was in the hospital. How could you say he has a funeral on 29th if you didn't know that he passed away, if you're talking about his funeral? And doesn't that seem like that's a feasible well, wait a second, one thing happened on the 22nd and then the other on the 29th. Why couldn't David be there on the 27th? What does that have to do with the fact that he was in the ICU until I got on a plane and passed away the day before? Absolutely nothing except to give a facade of truth, an appearance of truth. So after the hearing, the defendant's counsel argued that there was no excuse for the plaintiff not to be in court on the 27th. I should have been ready to proceed by myself with no attorney and completely try the financial end of this case myself. No excuse whatsoever. So the plaintiff was defaulted for his non-appearance. The defendant, Georgina Weigel, was ordered to submit argument papers regarding the issues in equitable distribution. So perhaps maybe the referee got information from her, which I gotta love this here, which the defendant promptly submitted. So, she's the good one, David's the bad one, because she was told to promptly submit documentation, and she did, and David did not, because he was never asked to provide information whatsoever about the finances. It's never been looked at. There has never been, in all 12 years of this fiasco, ever discovery done. Discovery's never been done. Not one financial fact, not one financial number has been verified in this entire process over the last 5 years. Over the last 5 years. So, but now the defendant promptly submitted it. But what happened to the discovery that was ordered on September 19th? Wait a second, this was Judge Tondra Dawson's order for discovery in September of 2019. Did Georgina Dimison promptly submit all financial documents for the previous 3 years, which is financial discovery? That's 30 months up until this point, 900 days. I was defaulted for being 27 minutes late for a lunch I had no reason to know existed. And
Say it again. I was defaulted. You hit your microphone.
I was defaulted.
Yeah, don't hit your microphone.
I was defaulted.
One more time. I was talking.
Wait, I was defaulted for being 27 minutes late for a lunch I had no reason to know existed. She's 900 days late on providing simple background financial information. Last 3 years of bank statements to make sure nobody's committing fraud, nobody's falsifying federal tax return documents, claiming a whole bunch of dependents just to stuff your income taxes on your unknowing spouse that you submit joint tax returns for at the end of the year. No discussion or verification of multiple reports and actual police reports, reports from financial companies, investigations from financial companies. None of this has been ever heard, ever discussed, ever heard. Yet they have a summation of our entire financial divorce without any of this. But it was very, very good that she promptly submitted that part, I would say. So as we just quickly go through this here, parties were married, blah, blah, blah. Okay, we have 2 children. Yes, we do. The instant action was commenced by the filing of the summons on a complaint. So this divorce commenced on April 8th, 2019. Incorrect. It was April 5th of 2019. So this document is false there as well. And seems to forget that I filed divorce against her. I'm the plaintiff. She's the defendant. The judge seems to forget that sometimes. I'm the plaintiff. She's the defendant. So on the grounds of the divorce, blah, 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 breakdown after 6 months. Here the referee who signs this at the end, after a review of all documents submitted, which means after I reviewed only Georgie's documents, I recommend the following. This is fair and equitable. She's only looked at documents from one side. This is a legal process. This is legal. So I recommend that the adjusted gross income for the plaintiff, David Weigel, was approximately $801,600 in 2018. Yes, I had a bonus structure at RBC. That was my best year of my entire life. But in that $800,000 is $300,000 of phantom income from previous year's bonuses that were spent by the defendant over the marriage with our 6 vacations a year, which was never my idea. But nonetheless, that money was spent. But that was not my income in 2018. That is a gross income amount. Okay, I actually made after taxes $170,000 in 2018. But still, that income is being pegged against versus the income from the defendant in 2020, of $160,000. Now, what happened in 2018 versus 2020? What is it? What happened? There seems to be some sort of a global event that happened where 2018 was one world, and what happened in 2020? Oh, global pandemic that shut down the entire globe. So again, Financial Fraud 101, you cannot purport two numbers as comparables that are anything but financial fraud. It is noted that the plaintiff's most recent income is not known since the plaintiff defaulted. That's the $64,000 issue here. It's that, hey, we don't have to look at your information because you defaulted. So we don't know what you have, so we have every right to just pick it out of the sky. Use numbers that are 6 years old, that are completely irrelevant at a point where now you have a completely different job, completely different licenses, completely different setup with assets under management, okay? After 7 seizures, after notifying your clients of these seizures and having a significant chunk of your clients actually leave because of that. So this is supposed to be equitable breakup. So in determining all the maintenance and support, okay, it's recommended that the defendant's reasonable needs with respect to maintenance is $12,000 a month. So this is a woman who's made between $300,000 and $400,000 a year for the last 20 years. She needs to maintain her lifestyle. I have to pay for her lifestyle because how could she support herself? She's just a lowly woman. She can't be expected to, be able to cover herself. I have to pay $12,000 a month because there's such a disparity between our income that does not exist. So it is recommended that the plaintiff pay $12,000 a month for a period of 3 years. And here it is, but this is retroactive to April 8th, 2019, when I filed divorce against her. Again, making it look like the opposite, but it's not. So that, in my book, is $430,000, $32,000 right there. So what's going to happen on the 25th when I go in there and the judge says, yes, this is exactly what's happening. Mr. Weigel, write her a check for $32,000 right now. And I say, Judge, you know that I had to file personal bankruptcy on November 20th because I saw this coming 5 years before. So you're ordering me to pay money that, in defiance of federal bankruptcy protections and just common sense of knowing you can't file bankruptcy if you have $432,000. This is all part of information in the family courts. They have the ability to pretend doesn't exist. This is what you need to know going into this system. If you're just coming into this system, this is the level of fraud. As for child support, and this really, really bothers me because with all the money flying everywhere, who gets shortchanged? The kids in all of this. Oh yeah. So the kids have child support needs of $40,000 a year. And this one is okay to split up 65, 35, right? I have to pay 65, she has to pay 35. This one's okay. So this turns out to be $2,200 a month, $2,207.29. So what I did with the agreement that we made and submitted on March 11th is I more than doubled that. My kids get more, $5,000 a month. My kids are not going to be the ones that are shortchanged here. The plaintiff shall pay $2,200, blah, 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 commencing, da, 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 and that all additional costs will also be split 65-35. Nope. In my agreement with my ex, submitted on March 11th, I've agreed to pay 100% of all children's expenses just to end this. Not 65-35, not $2,200 a month, $5,000 a month, 100% of the kids' expenses, including college, which about $1.3 million if you're figuring about $250,000 for college. So as to the equitable distribution, now mind you, they have no financial documents. They know nothing of what assets or debts that we have because they've never allowed it to be submitted, okay? So I recommend that because they don't know what we have as equitable, I recommend that the parties each shall be awarded 50% of the marital assets. So whatever you got, just split it 50-50. That's a way to deal with it. As for the former marital residence, which you see here, 59 John Street, I recommend that the property be placed immediately on the market and sold, and that the parties each be awarded 50% of the proceeds. Previously, that said she gets 100% of it. That's what was changed. But now it says the defendant, again, are you confused who the defendant and plaintiff are? The defendant is awarded exclusive use of the residence until it's sold. I've been living here since we bought it in July of 19. She moved out in 2020. The children live in Connecticut for 3 years. How is Georgie going to live in this residence when her children live in Connecticut? Who is supposed to watch the minor children? She can't live in both places, right? She's responsible for the maintenance and the use of the property. Until the property is sold, the plaintiff is responsible for the mortgage. Of course, you know, why not throw anything in there? So she can live here for free, I'll pay the mortgage, of course. Any asset or property solely in the plaintiff's name shall stay in the plaintiff's name. Oh, now you realize that there's no assets to split up. So that's one broad way to deal with it. Any asset or property sold in the defendant's name shall stay in her name. As for counsel fees, always towards the end. Always. First, you have to justify absurd numbers, which then make the absurd legal fees look a little bit more aligned, right? So now, as for counsel fees, to be responsible 50% for the defendant's counsel fees of $400,000. So I'm responsible to pay directly to her attorney $200,000, of which her attorney rejected the referee report and said, no, I need to pay him $400,000 because I've got to pay for his work in this. I have to pay for my abuser, pay for the person who arrested me 4 times, pay for the person who prevented me from having a Christmas with my children or even speaking to them on my 50th birthday, pay for the guy who did everything in his power to prevent the fact of me even speaking to my children on Father's Day. I have to pay him $400,000 for this. That's a system that's a situation that you've heard countless guys talk about. When there's a disparity between a husband and wife, where one makes a lot of money and the other one does not, you pay for your abuser. That's what the system is set up to do. Further, the defendant is entitled to a judgment on the divorce grounds. So she's entitled to it and to take her name back. Very, very, very good. All right. So basically wrapping this whole thing up, this constitutes the report and recommendation of the special referee. So this report, it is signed and stamped by Sue Ann Honig. This is her recommendation, a woman we have never seen, never spoken to, never had a single conference with. I had an email exchange. Send me proof. Okay. She's made a complete assessment. This is her report. Bullshit. This was 100% written by her attorney. 100% written by her attorney. And going to be validated on the 25th. So honestly, I don't know if, I'm pretty sure I overspoke about all of this. I'm trying to do this from the fly. It's obviously extremely upsetting. I don't know what else can be done. All I know is that the judge can deem any and all of this in the nature of child support. And I'm going to close on this. And this reminds me of something Joe Rogan said about his friend Foley, who was married to a woman with no children and put him through everything I'm going through. And in California, they got the same scam set up over there. And the judge actually said the words that knocked Joe Rogan off of his chair. Said, your ability to pay has nothing to do with your obligation to pay. Joe's like, what the? How do we live in a country where a judge says your ability to make money has nothing to do with your obligation. You owe 20 grand a month, find the money. This is it. This is the absurdity. This is all I can put forth at this point. I hope that I'll get more people and more interested parties on board. I am hiring an entire group to build the AI systems and train the models to replace the entire family court system, or at least initially be a accuracy verification tool. But I'm going to use my case, all 6,000 files, submitted as a proof of concept. If it takes me 5 years to do it, AI will prove from the sum of all human knowledge in an uncorruptible system what actually went on here. And probably doesn't, strike anyone that that's going to be heavy lifting, but at least we'll have the numbers of what percentage of the decisions made in this case followed the evidence. Really, 2% ChatGPT? Only 2%? What does that mean? Wait till we start looking at and following the money. Everybody knows on Wall Street. You want to find who's lying, you follow the money. I will sit here and say, I will bet my life, my license, everything that I have. If this case is investigated, there is absolutely no way when tracking the money you will not see how the $6,000 a month I paid to the court supervisor versus it costing $2,000 if I used one in Connecticut, which I came to them about 30 times, and they said, no, 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 no. Why am I forced to use a private company that's charging 3 times more? Because do you think for a chance that this money is not kicked back to the judge? Not a chance in hell. It's not going to be 3 levels deep. It's going to be right there in the open. Mark my words. Anyway, this has been a very long video. Thank God for editing. Thank you, everybody that have stuck with me over this very tumultuous period, and have been my pillar of support. I did get my kids back, yeah, but I need my ability to protect them. I need my ability to provide for them. That's not what's going on here. What's going on here is punishment for speaking up about fraud and government corruption. So I hope, I can only pray that more and more people join in and we form a force to be reckoned with. Thank you.